Hi, my name is Andrew Kinney. I'm an attorney at Hogan Law Offices. I've practiced in the area of Social Security and Disability law since 1992, and as of this filming, we're talking in 2014. Hello. This is a classroom format. I want to discuss Social Security and Disability law from the ground up. There are previous discussions of Social Security Disability 101. This is, in essence, a classroom type setting. We're going into more detail under 201. In the previous discussion, we talked about the application stage, sort of a typical overview, but getting into some more detail. Now, the second stage, if someone is denied at the application stage, which roughly takes about 4 to 6 months, and there's some exceptions, but if someone is denied, the letters by procedural due process of the U.S. Constitution, the letters explain what you need to do to appeal. So if you're on your own and you get a denial, well, you can look, and by requirement of law, you see discussion about how you're to appeal. And usually it's a reconsideration stage, but there are a few states, like California and Michigan, there are some states that the letter will explain that you need to request a hearing. Just look at the form. But what you have is 60 days from the date that you get the letter, although you don't want to play around with it, to appeal. Now, the only time that we argue technicalities is if the client that we're helping doesn't get a copy of the denial, nor do we. And so you don't want to be having to argue about a day here or a day there. You want to make sure to appeal as fast as you can. One way is to be going to a local Social Security office, especially if you're on your own. Another way is to request reconsideration online and you get a receipt. That's a very quick and efficient way to make sure you appeal the application denial and you get to the next level. Now, what is the reconsideration and why is it there? Well, that's a good question. As you've heard me say a little bit ago, there's some states that don't have reconsideration. There's a reason for that. It is, in my view, a fairly useless step. The problem is that regardless of what I think about it, it's still required in most states. So even if you think there's nothing that it does, and actually I see a lot of rubber stamping, a lot of copying of language into the analysis of reconsideration, there are exceptions. So what I want to do in a level that approves application, roughly approvals are about a third of cases. Reconsideration dips down to 15% or less. What helps someone get approved at the reconsideration? So here's some more detail about that in my experience. At the reconsideration stage, if you have to do it, you might as well do it your best, okay? One thing that may be missing is that there may be medical records that you told Social Security about and for some reason Social Security didn't have them, or there may be medical records that you forgot to tell Social Security about, or thirdly, there may be new medical care that you didn't have at the first step, because the application step again is roughly half a year. Things can happen. If there's a new MRI, for instance, around the time about a month before your application denial, Social Security has already gotten the records that existed and had processed your case. So make sure to have make sure to have your look at the application denial and understand why you would have been denied, because it'll also have, other than form language but why you denied, there'll be a discussion of what records that they had, and in there you might see, for instance, if you had a consultative exam for mental health or physical problems, they would list that out, but they'll also list other sources. Look to see if there's any missing. At reconsideration, we have new evidence that we just discussed. The other way to get reconsideration to actually, since again you have to do it, to make something happen, is get input from a physician, usually in writing. Input about what? Well, if, for instance, you know that you have MS and you know that you're denied at the application stage, the question ultimately has to be, well, it isn't clear how the MS limits me, because depending on your age, you're trying to establish that you cannot do full-time work, okay? So if you get denied at the application and have a valid diagnosis of MS and have problems, well, at the reconsideration stage, you have to think, well, maybe it's not clear how you're limited. Maybe you have optic neuritis that comes in flares, but you have ongoing vision issues despite the flares. Maybe there's a misunderstanding based on just the record of your coordination issues. Quite frankly, whatever you tell doctors, it's tough to guess at what is actually in the medical record. If a doctor spends a little time with you, there's a better chance that you have a less precise record. So at the reconsideration stage, what in this context here, my advice to clients is to make sure to see if there's something new, something different, or in the case of getting a letter from a doctor, a letter from your treating doctor, let's use MS as an example, that discusses the diagnosis, discusses how the diagnosis was reached, discusses your limitations found on exam, and lays out whether full-time work is reasonable. That can be in a narrative letter or just an open letter format. Our office uses targeted limitation tables, but in any event, the idea here is that it gives you a better chance than the miserable numbers at reconsideration. Here's some inside information about state agencies. I know for a fact that state agencies review approvals at a much higher rate than they review cases that they deny application. So if that gives you any insight into what the gamesmanship is here, I believe it's best to consider that the state agency is looking to deny cases. Certainly the burden is on us to prove someone's disabled, but if there are errors, they're looking for errors in approvals much more often than looking for errors in denial. So on a very fundamental level, the system is stacked against you, and my message is if you can work, work. If you can't work, know that people are routinely denied when they shouldn't be, and I find some egregious errors, in hearings last week, for example, or even yesterday. These two steps here, make the best if you can with reconsideration. It may be the same length of time waiting as the application. If you change your address, your client changes your address, make sure to let Social Security know. If you change your last name, make sure Social Security knows, because some records are under the wrong maiden name. There's some details here, and as you advance into this process, that it's important to get a sense, what's the goal? That Social Security has all the accurate records and updated records, and if you can, has specific information about your limitations from treating doctors. That will not guarantee an approval, but it will set your case up, because if there's very clear limitations, it's very common for it not to be picked up on or ignored. And then you go to a hearing and you argue the errors at the lower levels, and in fact I find it very easy to argue errors at lower levels. Some cases should be denied. Some cases are borderline. Others aren't. Keep in mind too that Social Security has constituted examiners. They are independent practitioners, but yet some, and certainly where I am, are paid to do this almost full time. They don't have any other practice. What you'll find is, and I've seen this more often where I'm coming from, is that you'll have Social Security paying constituted examiners for a psychological evaluation or a physical exam. And I've even seen cases where they said there's not sufficient evidence from the case file to make a decision about, let's say, depression. They have you meet a psychologist. If the psychologist says that you are disabled, I've seen Social Security, and this is the state agencies doing Social Security's work at the first two levels, ignoring their own constituted examiner. And I've successfully argued that when they ignore their own constituted examiner, they're using excuses that are generic in form letters. For instance, they will say it's a snapshot of your depression, but they know full well that it always will be. So there are errors that are made at the first two levels, very common errors, very easy errors to pick up. Do not give up if you know you have a valid case. Again, work if you can, appeal if you can't. Hopefully this helps understand the first two state agency levels with Social Security disability claim. If you have any questions about Social Security, feel free to call the number at the bottom of our screen. Thank you.